All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Court officer, good morning or good afternoon, better. Court officer, could you please call the case?
Good afternoon, Madam President. Good afternoon, Your Honors. Situation in Uganda in the case of the prosecutor versus Dominic Ongwen, case reference ICC 0204-0115, and for the record, we are in open session.
Thank you. My name is Luz del Carmen Ibáñez Carranza. I am the presiding judge in these appeals. The bench is composed by Judge Piotr Homansky, sitting on my right, Judge Solomi Bosa, sitting on my left, Judge Reine Alapini Gansu, on my right, and Judge Gocha Lorquipanitse, sitting on my left. Before I take the appearances, I would like to apologize to the parties, participants, and the amici for the 3-hour delay today. The Chamber has instructed to the registry to investigate this incident and submit a report. Now I will ask the parties to make their best efforts to make their submissions and to stick to our original schedule. I will take the appearances now. I invite the parties and participants to introduce themselves for the record, beginning with the defense team of Mr. Ongwen. The defense team of Mr. Ongwen, please. Identify yourself, please, for the record.
May it please your lordships. I am Crispus Ayena Odongo, lead counsel for Dominic Ongwen, and I'm being assisted by co-counsel Chief Charles Acheleke Tako. With me also is Kifude Gordon, assistant to counsel, and Morgan, case manager. We are being joined on link by Mr. Obof Thomas, who is in Ohio, US, and Beth Leon, who is also in the US, in New York. We have our client, Mr. Dominic Ongwen, the appellant, in court. Thank you, Madam.
Thank you very much. Yes, I note for the record that Mr. Dominic Ongwen is also present in the courtroom. Welcome. Counsel for the prosecution, please.
Good afternoon, Your Honours. Appearing for the prosecution today in the courtroom, we have Ms. Marichal Reggae, Appeals Counsel, Mr. Matthew Cross, Appeals Counsel, and Mr. Matteo Costi, Appeals Counsel. And then appearing on your screens remotely, there is, from left to right, Mr. Reinhold Galmetzer, Appeals Counsel, Ms. Priya Narayan, Appeals Counsel. Above her, Ms. Naveda Tharu, Associate Appeals Counsel, and next to her, Mr. George Mangwana, Appeals Counsel. And my name is Helen Brady, and I'm the Senior Appeals Counsel for the prosecution. Thank you.
Thank you very much. And now, the legal representative of the two groups of victims, starting with victims represented by Mr. Joseph Agwenyu Manhova and Mr. Francisco Cox, referred to by the appeals chamber in the appeals as Victims Group 1.
Good afternoon, Your Honor. With me, Mr. James Maguire. On screen, Anushka Semi and Priscilla Ailing. Thank you very much.
Thank you very much. And now, victims represented by Mrs. Paulina Macida, referred to by the appeals chamber in the appeals as Victims Group 2.
Good afternoon, Madam President, Your Honors. The victims represented by the common legal representative today are represented in court by myself, Paulina Macida, Principal Counsel, accompanied by Mr. Orcholona Ransetsek and Ms. Caroline Walter, both legal officers. Thank you very much.
Thank you. Finally, will the amici providing submissions today introduce themselves for the record, please? I would like to start with Felicity Gary, Quisi, remotely. Is she present? Please introduce yourself.
Good afternoon, Madam President and Your Honours. My name is Felicity Gary, Queen's Counsel. I'm leading and appearing on behalf of the group. We are individually named on the issue of non-punishment. I'm joined online by Jennifer Keane McCann, Anna McNeil and Ben Douglas Jones, Queen's Counsel, but I will be making the submissions today. Thank you.
Thank you. Now, the PILPG, Professor Michael Scharf, present in courtroom, please.
Good afternoon, Madam President, Your Honors. I am Professor Michael Scharf, Dean of Case Western Reserve University School of Law and the managing partner of the Public International Law and Policy Group. With me in the courtroom today is Milena Stereo, the managing director of PILPG, and appearing remotely, if all works, is Jonathan Warboys, who is participating by video link. Thank you.
Thank you. Now, Professor Brackman, he's in courtroom.
Good afternoon, Madam President, Your Honors. My name is Mario Brackman. I'm a psychiatrist as well as an ethnologist. And I work at Tilburg University. I'm professor there of forensic psychiatry, and I work within the Department of Criminal Law. Thank you.
Thank you. And now, Dr. Behrens, in person in the courtroom.
Good afternoon, Madam President, Your Honors. My name is Dr. Paul Behrens. I teach international criminal law at the University of Edinburgh.
Thank you very much. We have taken appearances from everyone. Thank you very much again. If the composition of the different teams were to change during the different sessions today, I would like to ask the parties and participants to inform the bench at the beginning of each session. I welcome everyone to this hearing of the Appeals Chamber, which is held in a hybrid manner due to the exceptional circumstances we find ourselves in caused by the COVID-19 pandemic. Since French is one of the working languages of the court, I will be alternating between English and French. Bonjour à toutes et tous. Nous sommes ravis de votre présence ici aujourd'hui. Bienvenue aux parties, aux participants et aux amici à cette audience tenue dans le cadre de cet important appel devant la Cour pénale internationale. Present at the hearing today are the judges and members of the legal staff of the Appeals Chamber, counsel for the prosecution, Mr. Ongwen and his defense team, the legal representatives of victims, and the amici curiae, invited to make submissions on issues to be discussed today, and staff of the registry. This is a partially virtual hearing, which means that some people are participating in person in the courtroom and others remotely, either from the seat of the court or in other locations. I would like to note that people appearing in person are properly distanced from each other in accordance with the relevant health protocols. De plus, un nombre limité de membres du public a été autorisé dans la galerie du public. Cela fait suite aux mesures de sécurité strictes mises en place à la Cour pour les audiences tenues pendant la pandémie COVID-19. En outre, cette audience sera diffusée en ligne sur le site Internet de la Cour avec l'auditeur habituel de 30 minutes applicable aux audiences tenues dans les locaux de la CPI. Nous espérons que cette audience se déroulera sans heurts et remercions les parties, les représentants légaux des victimes et les amis Curiae pour leur assistance et leur coopération dans les préparatifs afin d'assurer le bon déroulement de cette audience et de la procédure dans cette affaire. Au cours de cette audience, la Chambre d'appel est appelée à entendre les arguments et les observations des parties, des représentants légaux, des victimes et des amitiés portant sur les appels de la défense interjetés contre, en premier lieu, la décision de la Chambre de première instance numéro 9, en date du 4 février de 2021, condamnant M. Ongwen pour des crimes de guerre et des crimes contre l'humanité, et contre, en second lieu, la décision de la Chambre de première instance numéro 9, en date du 6 mai 2021, les condamnant à une peine conjointe unique de 25 ans d'emprisonnement. Je me référerai à ces décisions comme étant la décision relative à la condamnation d'une part et à la décision relative à la peine d'autre part. Before inviting the parties and participants, together with the Amici Curiae, to make their submissions, I will summarize the background of these appellate proceedings. The appeal on the defense against the conviction decision arises from the trial chamber's decision, which found Mr. Ongwen guilty of 61 crimes, comprising of crimes against humanity and war crimes. The appeal chamber has received written submissions on this appeal from the defense, from the prosecutor, the legal representative of victims, and on selected issues from 19 Amici Curiae admitted to participate in these proceedings in light of their expertise and high qualifications. The defense also appealed the sentencing decision where the trial chamber sentenced Mr. Ongwen to a joint sentence of 25 years of imprisonment. The appeal chamber has received written submissions on this appeal from the parties and participants, and were relevant from the Amici. The appeals will render separate judgments in relation to the appeals against the conviction and the sentencing decisions. On the 28th January 2022, the appeals chambers invited 10 Amici Curiae to participate at the hearing. In inviting these Amici, the chamber made an effort to balance the presentation of the views based on gender and geographic diversity, while at the same time minimizing repetition of views amongst them. I would like to extend the gratitude of the Appeals Chamber to those amici that, while not participating at the oral hearing, did make written observations on a very important aspects of these appeals. Your submissions are an important contribution to assist this bench in the determination of the fundamental issues engaged in this appeal. In its appeal brief against the sentencing decision, the defense raises, This is the background which leads to today's hearing. I turn now to the substance of the defense appeals. In its appeal against conviction decision, the defense raises 90 grounds of appeal consisting of alleged legal, factual, and procedural errors that, in the defense's view, materially affected this decision, as well as allegations of fair trial rights violations. The appellant divided its appeal into 6 sections, alleging several violations of Mr. Ongwen's fair trial rights, errors in the trial chamber's rejection on the grounds for excluding his individual criminal responsibility under Article 31(1) of the statute, errors in the trial chamber's conclusions on culture, errors in the trial chamber's failure to recognize Mr. Ongwen as victim of the organization known as Lord Resistance Army, hereinafter LRA, errors on its conclusions about LRA, Joseph Sconey's control over Mr. Ongwen, and errors in its findings on Mr. Ongwen's individual criminal responsibility in relation to the different modes of liability. The defense requests that the appeal chamber reverses the conviction and enter a verdict of acquittal. In its appeal brief against the sentencing decision, the defense raises 11 grounds of appeal, alleging factual and procedural errors that, according to the defense, materially affected the decision. While some of the grounds are intrinsically related to the findings of the trial chamber in the conviction decision, others raised important issues concerning, among others, mitigating and aggravating circumstances. This includes the trial chamber's assessment of Mr. Ongwen's individual circumstances as a former child soldier. The defense requests that the appeal chamber quash the sentence imposed by the trial chamber and impose a lower sentence or remand the matter back to the trial chamber. The appeal brought against the conviction decision is the largest ever considered by the appeals chamber. The appeal raises complex and novel issues concerning the assessment of grounds such as mental disease or defect and duress as grounds for excluding criminal responsibility. In addition, issues concerning the interpretation of sexual and gender-based crimes, in particular forced marriage, forced pregnancy, and sexual slavery, are equally novel and complex. This also presents a unique opportunity for this chamber to develop the interpretation of the law on some fundamental issues in the realm of the international criminal law relevant to the adjudication of the case. May I also remind the parties and participants, Turning now to the conduct of these proceedings. It is recalled that in the directions of the conduct of the hearing before the appeals chamber issued on the 28th January 2022 and the revised on 8 February 2022 document, the appeals chamber indicated both the order and the time allocated to the parties, the legal representatives of the two groups of victims, and the amici curiae, to address the appeals chamber on each day of the hearing. The speakers are requested not to merely repeat arguments already made in their filings, but to make submissions on the issues outlined in the order, being guided by the questions set out therein by the chamber. I will remind you to please speak slowly for the benefit of the interpreters. Moreover, the appeal chamber would like to stay as much as possible in open session during the 5 days hearing, especially in light of the fact that it is partly held on a virtual basis. For that reason, the parties and participants are invited to refrain from referring to information that has been classified as confidential, unless absolutely necessary. If there is a need to refer to such information, please alert the chamber before starting with your substantive submissions each day, in order to allow arrangements to be made in advance for closed or private session. I also remind the parties, participating victims, and the amici curiae that they are expected to complete their submissions within the indicated time frame set by the appeals chamber. The court officer will be monitoring the time and will indicate to the party or participants when it is about to expire. Now, I would like to invite the parties and participating victims to make their introductory submissions on the defense's appeal against the conviction decision, including any responses to the participating victims' written observations filed on the 21st of October. I am afraid that our schedule has been moved once again a little bit more, but in any case, all the defense counselors and prosecution counselors, you have 30 minutes each one, okay? Now we are going to start with the counsel for Mr. Ongwen. You have the floor for 30 minutes, starting now. Counselor, you have the floor. Thank you.
Madam President and Your Honors, permit me to open this statement with a proverb I learned in my early years. It goes, mean circumstances beget mean children, and the fruits rotten as they ripen. My lords, the appeal before you is about a child who was brought up under very mean circumstances. A child who, as a result of human trafficking, was abducted at the age of about 9 years because the government of Uganda, who shamelessly preferred the charges against him before this court, and the international community, which created the court that tried him, as well as this one, failed to protect him against Joseph Kony and his LRA. A child who was not rescued by the same government of Uganda and the international community from the armed conflict between the government of Uganda and the LRA. A child the government of Uganda and the international community failed to rescue from the evil grips of LRA for close to 25 years under enslavement, doing forced labor for LRA. Your Honors, Madam President and Your Honors, even at the time of the charges against him, Dominic Ongwen was and still is a child, because the spirits of Joseph Kony, in which he verily believed, possessed him, and he has not undergone any cleansing rituals required by his culture to become free of those spirits. One of the traditional leaders of Acholi, from where Dominic Ongwen hails, that is prosecution witness number 9, at transcript 83, page 16, lines 16 to 17, had this to say about Dominic Ongwen what Dominic Ongwen was during the charge period. And I quote, "If you go to your child and your child speaks like that, wouldn't he be showing his bitterness to you? If you go to your child and your child says, 'Daddy, this and that has already happened to me,' Your Honors, Madam President and Your Honors, it is important to underline the fact that even at that time, this traditional leader recognized Ongwen as a child. It is, of course, quite mind-boggling, though, that in the end, this same daddy figure turned around and joined the chorus of the prosecution and the victim's representative to shout, "Crucify him, crucify him." And of course, unlike was the case of our Lord Jesus Christ, who Pilate did not find fault with, the trial court found fault with this man and convicted him and gave him an unimaginable number of years behind bars. It is our voice, it is our hope that another chance has come today in this court. I shall deal with the status of Dominic Ongwen as a child in more detail when I come to his mental status. But let me proceed to say the above statement of that witness cannot be viewed otherwise than that he was tacitly recognizing the innocent child Dominic Ongwen was. Your Lordships, before I delve into the main issues of my opening statement, permit me to start with some otherwise pertinent issues which were not necessarily my lords, I have just received information from my co-counsel, Beth Lyons, that is totally shut off, and she's not listening to to the proceedings of the court. And I must inform court, Madam President and Your Honors, that this has serious consequences on the arrangement of the defense, because what my colleagues are going to say, in particular Beth, who is going to deal in details with the issue of Article 31(1)(a).
One question, Councillor. For these first introductory submissions, do you need your counsel?
Oh, yes, because the arrangement, the way we have done it, is that, our presentation flows directly from my presentation.
But now you will take your 30 minutes by yourself, or your co-counsel will be speaking part of this time.
No, I will take it for myself.
Okay,
By myself.
then please continue with your submissions. We will take care after the end of your submissions. We take note of your concern. Okay, thank you. Wait a minute, I will stop. Thank you, Councillor. And then you will be finalizing your submissions in the 30 minutes around. Then we are asking what is happening. Then we will allow the prosecution to make their submissions, and then we will see if we need to stop just to permit your co-counsel to come with us to reach the transmission of the hearing. Okay? Please, continue.
I'm much obliged, Madam President and Your Honors, save for the fact that I want you to take cognizance of the fact that time has been spent on this. I hope it will be put on my credit side.
I will give you 3 minutes more, okay?
You took more than 3 minutes.
5. Then 5, it's okay. Thank you.
Yeah.
5, it's okay.
I want to deal with some important matters that were not directly put in the question. And number one is that the prosecution submitted at paragraph 7 of their response brief, that by the defense incorporating by reference arguments from previous submissions, they impermissibly extended the page limit. Madam President and Your Honors, our answer to this is that this is not correct, because as a matter of fact, you will see that the defense used a total of 235 instead of the permitted 250. And in any event, we made specific reference and quoted the footnotes that were already indicating documents which are already on court record. We give an example of footnote 15 of paragraph 15 of the defense appeal brief, references to paragraphs 4,261 to 4,272. Footnote 57 refers to paragraphs 73 to 82, and so on and so forth. And as for the defect series, Madam President and Your Honors, This is part of the record, and therefore making reference to it does not in any way prejudice the prosecution. In any event, the prosecution has not demonstrated that the references extended the page limit. Like I've already said, the defense recalls that the length of defense appeals brief is only 235 pages, as opposed to the permitted 250. The prosecution has failed to demonstrate that these paragraph references in support of the defense appeal submissions, when combined, extend to more than what was permitted. Pursuant to Article 74.2 of the statute, the Chamber must base its decision and judgment on the entire proceedings on the trial record. Madam President and Your Honors, it is the submission of the defense that indeed this is a basic reason why the appeal is before you. The trial court did not base its decision and judgment on the entire proceedings. The trial chamber decided to cherry pick what was helpful in making sure that they attained conviction. And we dare say, if you take a very close look at the manner in which the conduct of the proceeding was made by the trial court, it appears that the court came with a predetermined mind to convict Dominic Ongwen. And we are not surprised by this, because the background to this case was a ferocious and atrocious war by the LRA in northern Uganda. And this went viral on the international media. And I think everybody was looking for a chance to deal with LRA. And when Dominic Ongwen appeared before this court, it would appear the trial court found a chance and said, finally, we've got them. But it is our submission that, just like was stated, I think, in Goa's book of company law, a court is like an auditor. A court, according to that quotation, that reference I'm making, it said, an auditor is not a bloodhound. He must approach his work with an independent mind, not coming to find a thief. In this case, I think the court is also enjoined to approach its work with an independent mind, not with a fixation of mind that they're coming to convict somebody who has already committed a crime. Madam President and Your Honors, there is a problem about the judgment, evaluation of evidence, especially in terms of, in respect to intercept evidence. Intercept and, documents which were brought before court. My lords, there is a basic principle of chain of custody, which is important for evaluation of intercept documents. But the important thing that we want to draw the attention of this court to was the submission of the prosecution at the beginning of the trial. They said nearly or more than a half of their evidence was based on intercept evidence. Now, you will find, my lords, that in the proceedings, in the valuation of evidence, the court decided to throw out most of this intercept evidence. And these were very telling, they had very telling pieces of evidence. And this was merely on the ground that most of them were not in the working language of the court. But the contradiction, my lords, is that they instead decided to, apart from, after failing to admit the intercept evidence, which were accompanied by contemporaneous notes made on them, they instead took the evidence of logbooks, which were based on memories of somebody who finally, memorialized it. So we fault the trial court for this. But most importantly, my lords, if it was the position, if it was the case of the prosecution, that their case was based on, half of it was based on intercept evidence, you may want to query, after most of the intercept evidence was thrown out, how did the prosecution reach the threshold of proving their case beyond reasonable doubt? My lords, I now go to the mental state of Dominic Ongwen. My lords, before discussing the important matter of spirituality in the LRA, I propose to start with the mental state of Dominic Ongwen at the material time. This is because the question shall inevitably be asked at the end as to what may have caused his mental state at the material time. And I'm sure I don't have to overemphasize the fact that this has a bearing on the issue of duress. Not only that, it also has a bearing on the question whether the trial court was right to put Ongwen on trial. On the first day of the trial, your lordships, the defense said in its opening statement made two important statements which should have been of great guidance to the trial court in their deliberations. And number one was that we said, never before has the world witnessed a conflict so complex in nature, steeped in metaphysics and spiritualism as the one that forms the contextual basis of the case before you. And the second one, we said, the accused who is the subject of this investigation was just a child when he was abducted, brutalized, and made into a fighter machine without a mind of his own. Unfortunately, Madam President and your honors, the way the trial chamber handled the case, it seems obvious that it did not take heed of this. If the trial chamber had put stock to the two statements above and heeded the caution, they would have avoided the errors pleaded in this appeal. The simple message in those statements was, treat the accused as a former child soldier entangled in Cohen's spirituality. There is no gainsaying your honors that the spirituality in the context of this case was so inextricably interwoven with duress that the proper understanding of the former would aid the appreciation of the latter. And it would have answered most of the questions that the trial court was faced with, and we would have gone home much earlier. Unfortunately, this was never to be done. I now talk about spiritualism and its effect in the cultural context of an Acholi's child soldier. Your Honors, we shall adopt the positions in the reports of the following amici on spiritualism. We adopt the definition of spiritualism given by Professors Erin Baines, Camry, and Clark, and Mark A. Drumby, paragraph 27 of document, I think it is 1929, I'm not too sure. And they say spirituality refers to a set of, maybe I don't need to go there since time is not my best ally. We also agree with their observation in paragraph 28 that spirituality played a large part in the indoctrination of child soldiers. Coin institutionalized the practice of magic as an existential function in order to explain fighters' misfortune and so on and so forth. We also agree with Bain's finding in paragraph 29 that child soldiers' loyalty to Coin and belief in his powers increased among children who were with the LRA for longer than a year. The younger the child was when recruited, the more likely he or she would be easily indoctrinated. They described LRA as both a political and spiritual project that reimagines the child as someone who can be purified and made into superior being. I will not finish the quotation. It is on record. What is contained in the above report of the amici were canvassed and established, Your Honors, by the testimonies of many witnesses across board, both prosecution and defense. And it established, and the court chose to totally disregard them. For instance, this is what a prosecution witness who was a former practicing spiritualist in Acholi, somebody called a Juaka in the language of the Acholi. These are people who had the kind of power akin to what Coin himself had, and had deep understanding. At page 44, lines 6 to 8, he said, in Acholi, everyone knows, it's common knowledge, that Coin is possessed with spirits, and he uses spirits. I do believe that Coin was using the spirit in him to confuse. At page 9, and it goes on, I will not finish the quotation. At page 9, lines 16 to 19 of the same transcript, 82, he says more or less the same thing. At page 19, lines 8 to 11, in my own view and how I have assessed it, Coin's spirit helps him more than myself, and so and so. Because if you see that the whole world go to follow him, but still manages to elude them, to elude and escape, that means he has something that protects him. For the record, Your Honors, for those who follow, the media, the other day, the USA again issued and gave a ransom of $5 million for anybody who can either capture or help to capture Joseph Coin. For 30 years, he has eluded everybody, including the most powerful army in the world, the USA. And prosecution witness number 9 again, at page 14, lines 18 to 22, made his voice again. And again, at page 15, lines 6 to 11, he said more or less the same thing, emphasizing what has already been said by the spiritual person. Again, at page the same page, I think, lines 9 and 10. He said, for you, you are led by the Spirit, and the Spirit will conduct all the activities around you. The Spirit knows what is going on. At page 16, answering the presiding judge's question, he said, when somebody is possessed by the Spirit, first he becomes confused and uncoordinated. His talks are uncoordinated and starts doing things which are unusual. He makes the same statement again at line 2 to 9 of page 30. The same witness again at page, proceeded to, at page 9, lines 16 to 19, said, I explained to the court that coin says he works with the Spirit. The people who actually control him in fighting, so he fights while he has defense in the Spirit. The same witness said at page 14, 18 to 20, line 18 to 22, when you are possessed by the Spirit, you work according to what the Spirit tells you, because your activities are, your actions are not ordinary. You are led by the Spirit. That means you are now led by the Spirit, and you are now a worker of the Spirit. At page 15, again, he's saying among the actual community, there is an outlined role of a spirit. When you are possessed, first it confuses you, he's saying more or less the same thing as earlier. At page 16, to the presiding judge's question, lines 14 to 16, they said, when someone is possessed by the Spirit, I think that has already been referred to. Then at page 19, lines 8 to 11, in my own view, and how I have assessed it, Coin's spirit helps me, because if you see that the whole world go and follow him, that has already been said also. He continues to say, in actually everyone knows, it's common knowledge. I think that's not very important. Page 45, line 6 to 25.
Council has 5 minutes.
My lords, UGA defense witness number 15 at 963 and 964 confirmed that Dominic Ongwen believed in spirituality, and the details are there. But most importantly, what the same traditional leader said about Ongwen. In other words, he was emphasizing that Dominic Ongwen was a traumatized child. But the first thing, before I even go to his testimony, is what happened at the detention center and also in this courtroom.
Councillor, I would like to ask you, please try to conclude because your time is about to expire. Thank you.
In the testimony of Ruotoyuak, witness number 9, he was explaining his encounter with Ongwen at different sites. And according to what he explained, and I emphasize this, I invite court actually to look at the testimony of Ruoto, of that witness. And he said when the man was aggressive, the man was very unhappy, and he kept on repeating this. At one stage, he was walking up and down, and challenging them, and he's saying, you people have spoiled my education, and all that kind of thing. Now, as far as we are concerned, this was definitely what you would call appetitive aggression, which had been discovered but dismissed or disregarded by the trial chamber. The trial chamber, also dismissed or disregarded evidence of two prominent, eminent, academicians from Uganda in preference to evidence from, I don't want to emphasize racism very much, but you could easily read it in this, because all the evidence that was given by, professors and experts who know better was completely ignored. And the evidence that was given by witness number 150, who was a practitioner and knew, was also discarded. Now you want to ask, who were the trial chamber completely to disregard what they had little knowledge of when they had a foundation to believe in the evidence that was given? My lords, Madam President, I know that you're about to stop me, but I can only say in conclusion that I take the position of the amica courier who supported the issue of non-punishment. This was a child. And the amica who talk about, when being somebody who was trafficked, was just like a slave. He provided slave labor, and therefore he should not be punished twice.
Councillor, conclude, please. You have 30 seconds to conclude.
I will conclude it by making reference to what the victims' representatives, how they were allowed to conduct issues here, like they were part of the prosecution. I think this is a matter that this court should look at very, seriously, because it devolves into fair trial matters. Because if we have to contend with three parties, the prosecution and the two representatives who are saying and backing up the same things, that is not
Councillor,
allowed.
thank you. Your time has expired. Thank you.
Much obliged.
Thank you. Now, Councillor for the prosecution, please. You have 30 minutes since now. Thank you.
My lord.
Wait a minute. Yes. Yes.
I have just received information from my colleague Beth. We are dealing with a very sensitive area of the case. This Article 31 is so central in this case. And my colleague, who is going to handle it, is saying that she needs to listen to the prosecution. I don't know how you're going to resolve that.
We are working on it, but now we are going to listen to the prosecution because we cannot delay it more. Then we will stop. But we are working on the issue now. Okay? Thank you.
My lords, will it not be putting the shoes after the thorn has already pierced you, like we say in Africa?
No.
Because if that
We need to continue with the hearing now because we are much delayed. So we are going to listen to the prosecution, and after that, we will stop to see. In the meantime, I can inform that we are working on the issue. I am about to receive the last report. Please, court officer. Okay, thank you.
Much obliged.
Counsel for the prosecution, you have 30 minutes starting now. I think, 30 minutes.
Thank you, Your Honours. Your Honours, Dominic Ongwen was properly and fairly convicted of 61 crimes amounting to war crimes and crimes against humanity after a trial lasting more than 3 years, in which the trial chamber considered evidence from 179 witnesses, both from the prosecution and the defence, and more than 5,000 other items of evidence. Dominic Ongwen's crimes occurred over a period of some 3.5 years and included a large number of grave crimes committed on a discriminatory basis against civilians during 4 separate attacks against camps of internally displaced persons, sexual and gender-based crimes committed directly by him and by members of the senior brigade, and child soldier crimes. These crimes included attacks against civilians, murder, rape, sexual slavery, enslavement, forced marriage as an inhumane act, forced pregnancy, torture, pillaging, and destruction of property. More than 130 people were killed during the LRA attacks on IDP camps. Hundreds of people were abducted, tortured, and enslaved during those attacks, and houses were looted and property destroyed. A large number of children were abducted, brutally integrated into the senior brigade, and used actively to participate in the hostilities. As a senior commander in the Lord's Resistance Army Senior Brigade, Dominic Ongwen played a key role in these crimes, planning them, organising them, and issuing orders. The trial chamber also found 7 women and girls were forced by Mr. Ongwen to be his so-called wives or domestic servants and endured his repeated rapes, sexual enslavement, torture, and forced pregnancy. At any time during the charged period, there were over 100 other abducted women and girls in the senior brigade, and they also suffered these crimes. In his role as commander, Dominic Ongwen played an essential role in sustaining the LRA's methodical abduction and abuse of such women. Ongwen himself was a child when he was abducted and recruited into the LRA. But he became an adult who rose up through the LRA's ranks to become one of its senior commanders, who embraced, further developed, and indeed implemented its policies. The trial chamber properly assessed all the evidence before it, including that related to grounds for excluding criminal responsibility, namely alleged mental disease or defect and duress, but found such grounds did not apply. In his appeal, Mr. Ongwen has largely repeated his trial arguments, but he fails to show that the trial chamber erred in law, in fact, or procedurally. His appeal should be dismissed and his convictions upheld. Likewise, his sentence of 25 years imprisonment was proportionate to the gravity of his crimes and his culpability. His appeal against it should likewise be dismissed. Your Honours, on the victim's observations, We have no additional comments to make about these, save to say that they are in line with our own positions. Now, we've addressed all of Dominic Ongwen's arguments in our response brief, including some of those mentioned today, such as intercepts. And so this week, we'll be focusing mainly on the areas that Your Honours have identified in the questions in the directions on the conduct of the hearing and any additional issues which may arise. And we have organised ourselves so that the prosecution's main speaker on each topic will be physically present in the courtroom, unless, of course, they need to be appearing remotely due to COVID restrictions. But at all times, all members of our team will either be present in the courtroom or remotely participating. Your Honours, I'll turn now to Ms. Marechal Regge, and she'll continue with our introduction. She'll first outline some key points to pave the way for some of our submissions later this week in the appeal, and she'll also give a brief roadmap on how we intend to respond in this appeal hearing. So thank you, Your Honours, and I'll pass it to Ms. Regge.
Thank you. Thank you. You can continue. Ms. Regge.
Good afternoon. Despite of what you have just heard from the defense, this case is not just about Mr. Ongwen. It is about his criminal responsibility for the crimes that he committed when he was a legally capable adult. But it is also, this case is also about the victims of those crimes. It's also about the mother of three who was killed by machete in Payule. It is also about Catherine Amono, who was carrying her child on her back when she was killed in Odek. It is also about Akelo Achi, Innocent Okelo, and Oyoko. They were 4 years old when they were killed in Lukodi. It is also about Hatari Anyima, who was shot, and his 2 children, who were burned to death in Abok. Like those and other victims, named and unnamed, they were killed, enslaved, and tortured by the LRA during the attacks against the 4 IDP camps in northern Uganda. These attacks all follow the same pattern, and Mr. Ongwen had a key role in each of them. I will recall some of the facts which underline his essential role and contributions to the crimes, and also show his promotion to the top ranks of the LRA. In Payule, Mr. Ongwen participated in the planning and in the execution of the attack. He led a group inside the camp. He ordered to abduct and to loot. He also took a group of abductees with him. He threatened them with death if they attempted to escape. In Odek, after Mr. Kony decided to attack, Mr. Ongwen chose LRA soldiers under his command to conduct the attack. He designed the attack, gave instructions, and set it into motion. He ordered to target everyone, including civilians, to abduct and to loot food. In Lukodi and in Abok, Mr. Ongwen independently decided to attack these camps. He planned and organized the attacks, and again, he ordered to attack everyone, including civilians, to take food and to abduct. In Mr. Ongwen's communications with Mr. Kony and other LRA commanders that Your Honors can find in the record of this case, Mr. Ongwen assumed responsibility or vividly described the commission of the crimes. Likewise, Mr. Kony praised his successes at work, also after the attack in Odek. And Mr. Ongwen rose through the LRA ranks during the period of the charges. He went from battalion commander at the beginning to second in command to the Senior Brigade shortly before the Payule attack, to brigade commander of the Senior Brigade shortly before the Odek attack. And Your Honors, this case is also about P226, who was only 7 when she was abducted by the LRA, and 12 when she was forced to become Mr. Ongwen's so-called wife. She and at least 6 other girls and women were held in Mr. Ongwen's household during the period of the charges and not allowed to leave. They were beaten and forced to perform domestic duties. Out of the 7, 5 became his so-called wives during the charge period. 4 were raped and sexually enslaved, and 2 of them were forcibly made pregnant and confined during their pregnancy. And they were not the only ones to suffer in the Senior Brigade, because Mr. Ongwen, together with Mr. Kony and other Senior Brigade leaders, systematically abducted girls and women in northern Uganda. If they were very young, they were used as household servants and referred to as tintings. They later became so-called wives and were forced to have sex with the man they had been distributed to. They live under horrific conditions, continuously abused and under threat. Mr. Ongwen played a key role in these actions. He helped to define and to sustain the LRA system of abduction and victimization of women and girls. He also personally distributed them to his fighters. He assigned them as so-called wives and then used his authority to enforce the so-called marriage in the Senior Brigade. The defense has emphasized today Mr. Ongwen's own experiences as a child soldier, but this case is also about the many abducted boys, like those from Lalilla, who Mr. Ongwen personally abducted. It is about P307, an abducted child, who thought that Mr. Ongwen will kill him because he did not salute him properly. Again, they were not the only ones. Mr. Ongwen, together with other Senior Brigade leaders and Mr. Kony, systematically abducted children and ordered them to serve as senior fighters. Again, Mr. Ongwen was instrumental in the commission of these crimes. Despite his own experience, he did not see these boys as children. As he himself said, and I quote, "You call those kids children, but I call them my soldiers." The Senior Brigade consisted of several hundred soldiers. It obtained new fighters by abducting civilians, including children. Recruits went through initiation rituals, where beatings were common. They were also forced to brutally kill and to witness brutal killings. They were threatened with death if they attempted to escape or did not perform certain actions. They were trained in fighting skills and subjected to a violent disciplinary system and extremely coercive and harsh conditions. The trial chamber acknowledged that Mr. Ongwen must have suffered similar experiences when he was abducted as a child, more than a decade earlier. Yet, there is a fundamental distinction between new recruits and low-ranking officers on the one hand, and on the other, senior high-ranking officers like Mr. Ongwen during the period of the charges. The latter had some level of autonomy, and they themselves were a source of threat and punishment. Also, Mr. Kony had to coordinate with them, had to rely on them in order to execute the LRA policies, in particular when he was in Sudan. Your Honors, this is a court of law, and we are bound to apply its legal framework. And the trial chamber did just that. It ensured the fairness and expeditiousness of the proceedings in full compliance with Mr. Ongwen's rights. It found that the 2 grounds excluding criminal responsibility that Mr. Ongwen alleged did not apply to him, it convicted him on the basis of a wealth of reliable evidence. Now, I would like to give you a brief roadmap of what are going to be our submissions for this week in response to your questions. Like we just did this morning, every day we will file a list with the authorities that we will cite during our submissions. Today, Your Honors, you will hear from Mr. Cross, Mr. Costi, and
Just to inform, thank you, just to inform to the defense that Mrs. Beth Lyons, defense co-counsel, is connected now. Okay, thank you very much. You can continue.
today, Your Honors, hopefully you will hear from Mr. Cross, Mr. Costi, and myself on how the trial chamber correctly found that the two grounds alleged by Mr. Ongwen as excluding his criminal responsibility did not apply to him. At trial, Mr. Ongwen had argued that during the period of the charges, he suffered from several mental illnesses. He also argued that he had committed the crimes under duress. The chamber correctly rejected both arguments. First, it found that there was no reliable evidence that Mr. Ongwen's mental capacities were destroyed during the period of the charges. It reasonably rejected the opinion of two defense experts based on a careful assessment of their reasoning and methodology. Instead, it relied on three further expert witnesses called by the prosecution, as well as other evidence, such as the testimony of lay witnesses who had closely interacted with Mr. Ongwen during the period of the charges. None of them described Mr. Ongwen in a manner compatible with the existence of a mental disease or defect under Article 31. Mr. Ongwen's careful planning of complex operations, his thriving within the LRA, were also found by the chamber to be incompatible with a mental disorder. Witnesses described Mr. Ongwen as a skilled fighter, a good leader, a socially skilled person. They described how Mr. Ongwen carefully assessed the feasibility of military operations, sought further information when needed, and openly stated his views. He was, in the chamber's words, a self-confident commander who took his own decisions on the basis of what he thought was right and wrong. Second, as to duress, the chamber found that Mr. Ongwen was not subjected to a threat of imminent death or continuing or imminent serious bodily harm when he decided to commit the crimes. The defense suggestion that his failure to follow Connie's orders would result in death was, as found by the chamber, totally unsupported by the evidence. Instead, the chamber found, and I will just highlight 4 findings. 1, that Mr. Ongwen was a high-ranking officer who was not in a situation of complete subordination vis-à-vis Mr. Connie, in the sense that he often acted independently and did not always execute his orders. 2, Mr. Ongwen had a realistic possibility to escape and didn't do so. Instead, he rose through the ranks, including during the period of the charges. 3, there was no evidence that the belief in Mr. Connie's spiritual powers played a role in Mr. Ongwen's criminal conduct. We have addressed the defense submissions on this point today in our response brief, paragraphs 355 to 363 in detail. And finally, Your Honors, Mr. Ongwen committed some of his crimes in private, where threats would not have an effect. Now on appeal, and in response to the observations of some amici, Mr. Ongwen has developed an argument that he already foreshadowed at trial. He says that he should not be criminally responsible ever because he has been victimized himself. But as we will explain, this argument is unfounded and the chamber already dismissed it. There is no rule under human rights law that perpetually immunizes a victim of human rights violations from criminal responsibility. tomorrow, Your Honors, you will hear from Ms. Brady and Ms. Narayanan that the trial chamber correctly interpreted and applied the distinct elements of the crimes of rape, sexual slavery, other inhuman acts, including forced marriage and forced pregnancy. The chamber correctly found that all these crimes are included in the statute, have different elements, and protect different interests. You will also hear from Ms. Brady how the trial chamber entered lawful cumulative convictions with respect to concurrent crimes. This is because the crimes have materially distinct elements that require proof of facts not required by the other. The trial chamber correctly applied the so-called materially distinct elements test, adopted by the ICTY Appeals Chamber in Celibici in 2001 and applied by international criminal tribunals thereafter, including the ICC. We submit that this test is correct and consistent with the Rome Statute. And on Wednesday, you will hear from Mr. Galmetzer on how the trial chamber correctly interpreted and applied the law on indirect perpetration and co-perpetration under Article 25(3)(a) of the statute. The trial chamber correctly applied the consistent jurisprudence of this court, which has been upheld by the appeals chamber in 3 different cases. And also on Wednesday, we will address any other issues arising from Mr. Ongwen's appeal against his conviction. And then on Thursday, you will hear from Ms. Thiru and myself on Mr. Ongwen's sentence. We will demonstrate that Mr. Ongwen received a proportionate sentence of 25 years, which reflected the gravity of his crimes and his culpability. It found that Mr. Ongwen did not have substantially diminished mental capacity during the period of the charges and reiterated that he acted free of threat in committing the crimes. Consequently, it rightly rejected the defense request to reduce his sentence on those bases. Instead, the chamber considered Mr. Ongwen's personal history in mitigation, as requested by the prosecution. In particular, the chamber gave substantial weight to Mr. Ongwen's abduction when he was 9 years old and his early years in the LRA. It reduced the length of the individual sentences by approximately 1/3, and then it reduced the joint sentence from life imprisonment to 25 years. And finally, Your Honors, on Friday, Ms. Brady will present the prosecution's final submissions. Your Honors, we maintain that Mr. Ongwen was correctly convicted and fairly sentenced. We respectfully request you to dismiss his appeals and confirm his conviction and sentence. Your Honors, this concludes the prosecution's introductory submissions.
Thank you very much.
May I please, Your Honors?
Yes, another interruption. Okay.
Arise to draw your attention to the question of time, and that looking at the time both of them have used, the court will compensate by giving more time to my friend, Bev Lyons, in her presentation.
Counselor, if I am right, please, court officer, I gave the counselor for Mr. Ongwen more than 30 minutes, 35, it was about 35, and now the prosecution has just taken 25 minutes, so there is no more time. What is your concrete request?
No, Your Honor, I'm just saying that I was not keeping the time, but I just said that there should be the computation of time. He was giving more time because of the interruption, the technical problems. It's not that we voluntarily.
But what would you like? What is your request?
Well, because of these technical problems and the ability of my colleague not to hear, probably there were interruptions. The court should know that she'll be talking from New Jersey and should make accommodation for time for her to be able to make the presentation.
We will see. We will see in the moment, okay?
She was entitled to hear all this because it has a bearing on what she's going to say.
But now, please, let us continue with the schedule of the hearing. Thank you. Well, thank you to the prosecution. Now, victims represented by Mr. Joseph Agwenyu, Victims Group 1, please, the counselor. You have the floor for 10 minutes, starting now. Thank you.
Thank you, Madam President, Your Honors. The victims we represent believe this case has been correctly and fairly adjusted. Mr. Owen was correctly and fairly convicted of 61 crimes, counts of war crimes, and crimes against humanity by the crime tribe. The evidence at trial showed that persons from the household of Mr. Dominic Owen gave testimony that he was a strict commander, but that he could differentiate and be caring with the children, making jokes, even disobeying orders from Mr. Coney. You can see that in the testimony of P16, among others. You can see that, Your Honors, in the testimony of P26, a woman who he kept for himself, even at the time of 1998. This is far before the alleged, the period, of the charges. And on an issue that was critical for Mr. Joseph Coney, the distribution of wives. The evidence in trial showed that Dominic Owen was a battalion and brigade commander, a member of Control Altar, and therefore played a significant role implementing LRA policy on abduction and attacks on civilian IDP camps. Moreover, he was an adult when he committed the charged crimes, which took place, and this is important also for duress, in a period of 3 years, 3.5 years, between 1st of July 2002 and 31 of December of 2005. Dominic Owen ordered his fighters to abduct civilians in the IDP camps of Pajule, Odek, Lukodi, and Abok, and personally participated in the abduction of children, male and female, and with other commanders, and distributed girls to be forced wife. His contributions were multifaceted, continuous, and essential. The life of victims and thousands of other people were affected and irreparably damaged as a result of his action. Many of those whom we represent have been left with horrific physical and psychological scars as a result of these actions. The trial chamber considered all the evidence before it and was guided by established legal standards and the statute and the jurisprudence of the ICC. On behalf of the victims that we represent, we submit to the trial that the trial chamber was correct in finding and conclusion on each crime to find Dominic Owen guilty. Your Honor, I must contradict my distinguished and learned friend from the defense. It seems that everybody that approaches this case from the abstract raises the issue of Dominic Owen being a child soldier. And like I say, in the abstract, this makes sense. It is when you see the evidence that you disregard this approach. Mr. Dominic Owen, when he committed the crimes, was not a child soldier. As one of our clients said to us when we met them, yes, he was abducted, but it seemed he loved his job so much. And this is something that is reflected by none other than himself. If you see Professor, I probably mispronounce his last name, Weisterstal-Pust, quoting De Jong, Professor De Jong's conclusion when he asked, how was it, Mr. Ongwen, that you rose through the ranks? And he himself says, because I was a good fighter, because I knew about ammunitions, because I did my job well. Your Honors, in the De Jong report, which is not a basis for the conviction, but it's interesting because since Dominic Ongwen decided not to speak to anybody else but the experts of the defense and the court-appointed expert, it's interesting to hear his words. He himself told Mr. De Jong that he did stroke people when they tortured civilians. Isn't this, or isn't it not, a reflection of actual knowledge of the unlawfulness of his acts? He could distinguish, he could control his acts, and he would decide. He would disobey Coney's orders. And therefore, Your Honors, I respectfully submit to Your Honors that none of the standards that have been posed for appellate review have been met by the defense. They have not met the standard for legal errors. It is well known that in legal errors, an appellate chamber may have more leeway or less deference to the trial chamber. And this is reasonable because legal standards can be analyzed just legally. But it's interesting that in factual errors, there must be, we submit, a higher, stricter standard for the appellate court to review the decision of a trial chamber. And this is based on general principles of criminal procedure. It is the trial chamber who has the benefit of hearing all of the evidence, posing questions to the experts, posing questions to the witnesses, and see firsthand, immediately, how these witnesses react, how experts answer. This is the basis why this standard of review for errors of fact has been even upheld by the Inter-American Court of Human Rights in the Catherine case, or the Loncos case against Chile in paragraph 294, where it says, and this is exactly the same standard that the ICC has followed, that for errors of factual errors, the appeal chamber must see that it was unreasonable to reach that conclusion, that it violates...
Counsel has 2 minutes.
I'll be finishing, Your Honor. That there has been a violation of common sense, of experience, of scientific knowledge, and that an objective reader could not understand objectively how is it that the trial chamber has reached its conclusion reviewing all the evidence. We submit, Your Honor, that anybody that reads the 1,077 pages of the trial chamber's decision to convict can see why, can see that they have respected common sense, that they have respected scientific knowledge and logic. Because somebody that decides to order to rape, pillage thousands of people knows the difference between bad and good. Thank you, Your Honor.
Thank you. Thank you, Counselor. Now, victims represented by Mrs. Paulina Macida identify in the case as victims group 2. You have 10 minutes starting now.
Thank you, Madam President. Madam President, Your Honors, this appeal is not about a child abducted at a young age by the LRA, injured and manipulated to the point of losing understanding and perspective of what was wrong and right, or put under such fear of death for himself or his loved ones that he did not have any other choice than to commit, in the most cruel ways, the 61 crimes he has been convicted for, both in the privacy of his home and in the bush and in front of his soldiers during the 3 long years covered by the charges. If it were, these proceedings would not be occurring before this court today. It is not disputed that Mr. Ongwen might have been a victim of one or several crimes when he was a minor. However, this fact alone does not constitute a legal basis for excluding criminal liability under the Rome Statute. The fact that Mr. Ongwen had been abducted at a young age does not absolve him from criminal liability for the acts and conducts he committed as an adult. By arguing that the situation of Mr. Ongwen should be addressed as if were a child and a disabled individual, the defense continues to entertain a fiction that is not only contradicted by facts, but also by expert evidence. Mr. Ongwen is an adult. He was an adult at the time of the commission of the crimes he's convicted for, and at that time, he had attained the stage of moral and intellectual development of an adult. His alleged disability has never been established at the time of the commission of the crimes, nor now. By arguing that Mr. Ongwen was under duress at the time of the commission of the crimes he's convicted for, and that he had no choice but to commit in the most cruel fashion each of the 61 crimes concerned in this case, the defense fails to acknowledge the vast amount of evidence to the contrary, and notably that Mr. Ongwen consciously decided to rise in the LRA ranks rather than trying to escape, as so many abductees did. The events Mr. Ongwen might have been a victim as a child when abducted are extraneous to this appeal. What this appeal is about is the correctness of evaluation by the trial chamber at the required standard of proof beyond reasonable doubt of the evidence pertaining Mr. Ongwen's conduct and actions as an adult. The ones that he chose to take or not to take at the time of a charged crime, and finding that he bears criminal responsibility as per the terms of the Rome Statute. The evaluation of the evidence by the trial chamber was correct in law and in fact, and the accurate standard of proof was applied to all claims the defense is presenting before this chamber. Your Honors, let's put the facts as supported by the evidence straight. During the period covered by the charges, Mr. Ongwen was a military commander in the LRA. He commanded a battalion in the Signa Brigade. He became a commander of the Signa Brigade. He had effective command and control, or authority and control over his subordinates during the entire period of the crimes. He knew about the common plan to attack civilians' population, in particular the Accialis or anybody supported as perceived as government supporters. He participated in meetings to plan the attacks. He gave orders to his subordinates to attack Lukodi, Odek, Abok, and Pajule. He explicitly ordered looting, destruction of properties, murder, torture, and inhuman and cruel treatments, as well as the abduction of adults and children under the age of 15 to be integrated in the LRA, including in the Signa Brigade, and used as soldiers. Mr. Ongwen himself used children as soldiers and bodyguards. He directly perpetrated sexual and gender-based crimes against young girls and women under his control. He ordered the adoption and distribution to commanders and soldiers, so that women and girls became wives, knowing in full the fate reserved to them. More importantly, as clearly demonstrated by the reasoning of a trial chamber, Mr. Ongwen had the necessary mens rea in accordance with Article 30 of the statute. None of the grounds for excluding liability has been proven by the defense. The evidence at the trial clearly and without any doubt points to the opposite direction, showing a different reality from what was depicted early this afternoon by the defense, indicating that Mr. Ongwen was without a mind of his own. He took active part in maintaining and enforcing the system of terror that the LRA operated, taking initiative, decisions, and actions fostering the crimes ordered by Joseph Kony. Mr. Ongwen is known amongst the victims as the most brutal of the men served Joseph Kony. He has a record of protracted atrocities against his own people and brutality against his 4 very young wives. He was proud of his achievements in the battlefield. He showed no remorse. This appeal, Your Honors, is also about the victimization suffered by victims and the qualification of the different crimes perpetrated by Mr. Ongwen and his subordinates. Madam President, Your Honors, beyond the theoretical debate we will entertain this week, thousands of victims are attentive to these proceedings. While we entertain arguments about the applicability to Mr. Ongwen of the provision of international human rights treaties, a right which we do not contest in substance, but which are not applicable in the terms the defense and certain amici curiae are pleading in this court, do not forget 4,065 victims participate in these proceedings.
Counsel has 2 minutes.
Their fundamental human rights were systematically violated for years, their lives ruined, as well the ones of their family. The extent of the prejudice they suffered tremendous. In this regard, and in concluding, Your Honors, as underlined by one of the experts called by victims at trial, and I will quote, an optimistic outlook focused on growth and recovery following insult and trauma can be facilitated through education, medical and psychological treatment, reparation, financial assistance, and the execution of justice. End of quote. This is, Your Honors, the legitimate expectation of victims from these proceedings. Thank you.
Thank you. We will now take a break of 30 minutes. Please, we will be resuming exactly at 15:22 hours, please. Thank you.
All rise, veuillez vous lever.